Question is that the motion be agreed to. The Honourable David Parker.
Thank you, Mr Speaker. I rise on behalf of the Labour Party to say that we will be supporting this bill to select committee. Mr Speaker, the Evidence Act 2006 is one of our most important pieces of legislation. It effectively codifies much of the prior common law and sets out rules that govern fair trials. And the Minister, if I could thank her for her speech, I thought that was a very clear exposition of the reasons for these changes that are proposed. I thought that the way in which the Minister dealt with the issues as to the way in which child witnesses can give evidence in alternative ways was balanced. It is a very difficult issue. We do need to stop victims and witnesses of awful crimes, including children who are witness terrible crimes, being abused through the trial process itself. But we also need to do fairness to the accused. Sometimes people are accused when they're not guilty, and I think one of the fear that most people would have in any society is that they don't have the ability to properly defend themselves against allegations, and they need to have a right to a fair hearing as well. I think that the way in which the Minister was careful to say that we are trying to protect victims, and in this case particularly children who may not be the victim, but they may be the victim, but they may also just be a witness to some other, for example, domestic violence in a household. The way that we are trying to protect the child witness in allowing more humane, it could be said, ways of them giving evidence, but still retaining the fundamental right of the accused to question that evidence through appropriate cross-examination is, I think, the right balance. I'm sure that there will be members of the legal profession as well as advocates for children and victims more generally, and victims, who will give detailed submissions as to whether the legislation gets the balance right in respect of that issue. Sir, in respect of restrictions on video recording evidence, I support those too, on the use of video record of evidence in sexual and violent cases. As the law currently stands, the lawyer who might be acting for an accused person, if that lawyer has access to and has a copy of that video, then my understanding is that existing law, they probably have a duty of disclosure to their client, which would put them in the invidious position of, although they might have a ratbag client, and actually lawyers quite often know that their clients are ratbags, but they still face duties to their clients of openness and disclosure, and to provide them copies of what they've got. And without this legislative control allowing this, the lawyer might be under a duty to give across that information, even though the lawyer might think that that's not in the public interest either. So we have to make sure, of course, that the accused and their legal representatives have proper access to the evidence that is being used against them, but nonetheless we shouldn't allow that to be copied and put out there on the internet, for example. So I agree with that one also. In respect of the requirements of giving advance notice, if an accused, if their prior sexual history is going to be used as evidence against them in the case that they are giving evidence in, then again, I think there should be warning of that. You shouldn't spring that upon someone. If someone's integrity is going to be, or someone's reputation is going to be attacked, if somehow someone's sexual history in other cases is going to be, in life, is going to be used as a way to undermine their assertion that they perhaps did not give consent to another sexual occurrence, then I think you should warn them. It's not to say it will never be relevant. I struggle to see how it's often relevant, but occasionally it could be. Where it is going to be put an issue, then I think that that should have to be warned, and the provisions of this bill seem wise in that regard. In respect of privilege for plea discussions, again, if you're going to have full and frank discussions leading to proper pleading, then that seems to be sensible. I would say that I have a slight concern about the rise of American-like bargaining around pleading. I know that I think that the current Solicitor General, who is responsible for the prosecutorial decisions that are made on behalf of the Crown, listened carefully to some complaints that had been made to me and at least one other member of the Select Committee, which we raised with the Solicitor General at either estimates or financial reviews last year. And I was very pleased that the Solicitor General took those seriously, and I was satisfied by his explanations this year that he looked into it carefully and that he didn't think that the accusations that were made were fair. So I accept that explanation, but I do think we all have to be careful that we don't fall into the situation where, because we're starting to bulk fund prosecutorial services, we don't want there to be a financial incentive that is inappropriate to settle for pleading guilty to a lower level of charge than reflects the seriousness of offence. We don't want that to become part of the New Zealand justice system. Nonetheless, I can see why we need full and frank plea discussions, and that privilege should be attached to those discussions. In respect of previous consistent statements, this puts the position back to where it was before the Evidence Act 2006 was amended. In that regard, large pieces of legislation like that do, despite the best care of this Parliament and the Law Commission, occasionally throw up things that we didn't get quite right. I think it's a testament to how good the work was on the Evidence Act 2006 that there haven't been many instances of that. One final thing, sir, that isn't within the scope of this bill, but which I would like to have seen fixed, is we still have this problem in respect of the evidence that can be gathered through search and surveillance mechanisms for the Serious Fraud Office in New Zealand. We have conferred protections on the media through the Search and Surveillance Act that was passed a couple of years ago in this House in respect of arms of the state other than the Serious Fraud Office, but including the police, which confers protections on the police. We've had problems with the media being subjected to inappropriate search and surveillance by an arm of the state, the Serious Fraud Office, most notably in the National Business Review case arising out of the South Canterbury finance controversy. And I just use this opportunity to put on record that I think we're overdue for fixing that up. And I know it was stubbornness on the part of the Prime Minister, Judith Collins, and there's a long record of how we tried to fix that. But I still think that's an outstanding matter that I would like to see fixed, because I want to protect media freedoms, including against inappropriate action by the Serious Fraud Office. So, who overall are a good office? I just think that that's a bit of law that still needs to be tidied up. With those comments, sir, I again record the Labor Party is supporting this bill.